Dear colleagues, good day. In a minute, we'll begin our session. Not everyone is here yet, but not to make you wait, considering the fact that we have many speakers and everyone will want to participate in this acute discussion. It's very actual in Russia at the moment. We've invited to our round table a number of foreign colleagues, practitioners who used to follow or are following big PPP projects in different countries. And today at this round table, we'd like to discuss the experience of our foreign colleagues who definitely have greater knowledge of infrastructural projects based on PPP principles. We also would like to discuss the trends of legislation development regarding PPP and practice of its usage. A year ago, when conducting this discussion, we've tried to do the wording of our topic to formulate whether there is a demand for PPP projects in Russia at all. A year later, we can say that there's only one single answer. Yes, there is a big demand for PPP projects, and the PPP notion is more frequently mentioned in different government documents and different concepts and federal target programs. But there are more and more questions on what is it, PPP, and whether certain mechanisms of financing of infrastructural projects are suitable, like non-contract ones, long-term target programs, and such unique mechanisms as DPM, whether all this may be united under the name of PPP project, and whether there are risks of requalification of what the regions call PPP, like it may be only the state order or the contract system or the other kind of relations between the authorities and business. And nowadays, at last, the federal government prepared and brought to the Duma, and Duma adopted in the first reading the federal law on the basics of PPP in Russian Federation. It is now actively discussed in Duma, Russian Parliament, among the experts as well. I believe this alone is already the answer to my last year question, whether there's perspective for the development of PPP projects in Russia. We would like to hear your opinion. Please participate in the discussion. I believe that if you have questions or perhaps remarks about what you hear, you should raise your hands. I quite recommend you to raise your hands, and me and my partner, who is still absent, will give the floor to you for sure. We've gathered here and we have time till 6 o'clock, so I believe everyone who will want to speak or ask a question will have such an opportunity. So let's begin. My name is Alexey Chichkanov. I am Executive Vice President of Gazprom Bank. And in Gazprom Bank, I'm dealing with infrastructural projects and investments of the bank into big projects. I also deal with PPP as one of the mechanisms of such investments. And in the beginning, I'd like to give the floor to Mr. Vladislav Zabrodin, the managing partner of Capital Services. Before the beginning, Vlad promised to provide an introduction to the topic. He will tell what's happening with PPP legislation at the moment and about the challenges that he sees since he's a practitioner. Thank you, Alexey. In fact, there were several interesting moments related to PPP in our lives. The first was Pulkovo project, which was a pioneer among PPP projects in Russia, since Alexei also personally participated in carrying out of this project, shall confirm my point of view. It was like walking along the minefield, and that was explained by the fact that a number of things that are already well known now and they're understandable for Western investors, they were new for them then, and it was difficult for them to perceive Russian realities and Russian legislation. For us to have an opportunity to carry out this project better and to demonstrate the necessary level of openness and understanding of the situation. When working at this project, we understood that we can't use the law on concession agreements. Thus, we oriented the project on St. Petersburg legislation on PPPs, and thus we encountered certain things that I should describe in detail. At carrying out of this project, it became clear that the law that was very modern and the first one of a kind in Russia adopted at the regional level was unfinished and not sufficient for carrying out of this project. And our work at Pulkovo project consisted of several parts, and one of the important parts of work was that for ourselves and for the partners who participated in that project, for the city authorities that did promote that project seriously, we thought what modifications of legislation are necessary for the project to begin being carried out, so that the project may really be carried out. Our experience we gained, the results we've obtained, I believe, became the basis for the development of the federal PPP legislation. How do I switch the slides? Great, thank you. If we look at the general situation, and I quite agree with Alexei about it, some 2 years ago, in some situations, we thought perhaps PPP is not better than the state order. Now we understand it's a good, efficient addition for carrying out for projects necessary for the government. Infrastructure is in a pitiful condition, it's well known, and the government, though it does have good resources at the moment, still there's never enough resources to improve the infrastructure to the necessary level. And the position of the leader of the state and of the regional authorities is that PPP is a very interesting, modern and efficient tool for the development of infrastructure in our country. If we see the situation from the point of view of legislation, initially the parties operated the law on concessions, but that law on concessions has a number of problems that are not suitable for PPP projects. They are unacceptable since the law on concessions was developed for different goals, and though it keeps being modified and improved, its very essence is rather conservative. And that means that it may not be used in all the fields where we would like to have the projects. It's not always usable for carrying out of projects. Thus, first, the regions started to form the law on PPP, and they actively used the achievements of St. Petersburg, things that we have formed. Initially, many regions Well, already over 60 regions have their local legislation on PPP. In the beginning, they just copied or used the format of the St. Petersburg law for their projects in their regions. But at a certain stage, it became clear that the presence of regional legislation is not enough. It is limited by the federal laws that may be used regarding the PPP projects. And the federal legislation is dominating. Thus, part of the agreements on PPP may be requalified, and thus the validity of these agreements may become questionable. Legislators understanding the situation and the risks and trying to satisfy the need existing both in the regions and on the federal level, decided that new legislation needs to be developed. And this new legislation caused the following. Now there are less contradictions between the regional and federal laws on PPP. The law, for sure, is a serious step forward for the carrying out of such projects. We are now actively participating in the development of this law. There were many discussions about it, and at one of the last discussions which took place in the High School of Economics, we encountered a very interesting opinion on behalf of the authorities. They say, now you are trying to treat this law as a rather general document, but it has to be very precise and has to give very detailed, stringent and precise instructions on how to act. Till it's like this, we can't use it. But in Russia, legislation is being changed, approaches are being changed, and financial situation at the markets of Russia and of the world has changed. And when developing this law together with other market stakeholders, we understood that you can't make a very precise law because it will not reflect all the trends existing at present. So the law that is developed at the moment is in many ways related to the system of regulation, and it gives a lot of opportunities. It is flexible enough, thus both the state and private partners have a possibility to develop individual schemes to achieve their goals. This gives the understanding to the authorities that this scheme is legally valid and justified, and it will enable private partners who do want to participate in this project, and it will enable financial institutions, bodies, to do the funding of these projects. It's not an easy task because each time we have these projects, most of the questions are coming from financial bodies, since the system of redistribution of risks and of providing of guarantees is an important part of PPP projects, especially of the PPP projects in Russia. Let me give you a small example, say Pulkovo. The risk matrix in this project was 900 items. You understand how comprehensive, how difficult it was to distribute these items between the parties in a fair way so that the parties do not feel treated badly in this project. The second question is the law on state procurement. We have the law on placement of orders. There's the law number 44, which is already adopted and comes into force since the 1st of January. And there exists a stringent position of anti-monopoly bodies, which are one of the parties that developed the positions of the law 44. They say that all the legislation regarding the relations of business and private government and private business should be strictly regulated, which I believe shall impede and shall be a limitation in PPP projects. Thus, We've discussed this issue for a very long time. It's not, we don't have a single opinion about it, but the group of experts has developed a number of suggestions, which is now being reviewed and adopted by the Parliament. We should bring this PPP law outside the legislation on state procurement. This has to be coordinated with anti-monopoly bodies. It's a lengthy and difficult process, but I believe it's possible to do it. We're optimistic about it. Since there are no general contradictions between the law on state procurement and PPP, some things just need to be regulated evenly in these laws, and it's quite an achievable goal. One more important point that should be noted, and that is what do investors want in this situation. And when working at this project, we know what the legislators pay attention to. They understand that there is necessary to have a clear system of the partners carrying out its responsibilities. Then the state shall be able to take its liabilities, and they'll be understandable for the investor, and also coordination with international practice. Gazprom Bank and VTB are intensively financing these projects, but money involved in this project shouldn't be, it's not Russian money only. It's the money of many different bodies, including international institutions. And when international institutions review these projects, they give a set of requirements and rules that are acceptable for them. It's important for partners and for the whole project because the funding is making the project realistic. If there's no funding, or if financing is too expensive or too comprehensive, then either the projects get more expensive or they stop being realistic. So this level of comfort that we want to provide to our partners and hence to the banks of those partners is one of the important things underlying which form the basis of this legislation. I will not give you too many details, but let me give you several examples of problems that should be solved in the new law on PPP. These are most interesting or most hazardous points. First of all, the relations on land ownership. You know that the handling of land from government to private property is a very sensitive topic, and from the formal point of view, to obtain the land, besides winning a tender on PPP, you also have to win a tender on transfer of rights for the land plot. And from the point of view of procedures, it's not logical. St. Petersburg has solved the situation for itself, but now we should solve it on the federal level to unite these things, the two tenders. So I believe the transfer of these objects and the right for signing of the agreement and the right for the land side should be on the basis of the same tender. It's possible. We have good solutions of a kind, and it seems like the parliament members seem to like this solution. The other point is the tripartite agreement, and it's one of the contradictions in the law on concessions. Usually in such projects, besides the government, the public party and the private party, there are also some companies that belong to the state. Like in St. Petersburg, it was the Pulkovo company and the West Speed Diameter company, which belonged to the state. 100% of shares belong to the state. But at the same time, these are companies, and if the company is absent in the project and cannot sign the agreements, that increases the risk of the project, because they already have some permissions that are necessary for carrying out of this project. So now we are looking for the possibility to sign tripartite agreements. It's a serious step forward. It will be. Next point, one of the most serious issues, that is the opportunity to transfer the property rights on the object. Concession legislation mentions that it's impossible to transfer the rights for property objects. Some modifications are already taking place in this field. In some fields, concession legislation says, as for the utilities or roads, we are perhaps ready to allow such a transfer. But regarding the basic other spheres, it's still impossible. And PPP legislation now provides such an opportunity and offers a private partner to get the rights for property objects, the title for these objects. The other point is budget and legal relations. Budgets are coordinated for 1 year, and there are financial liabilities that may be up to 3 years, the so-called budget assignments. But the PPP agreements are signed for a much longer periods of time, like Pulkovo is 30 years. And thus you cannot provide the budget guarantees that far in advance. This problem isn't solved yet. Then comes the question, how can one provide certain new kinds of budget assignments, allocations that could cover those potential liabilities of the public partner? We're now actively discussing this topic. On the 23rd, there'll be a discussion in Rossiyskaya Gazeta, Russian newspaper. Then there'll be the second hearing in the Duma in the beginning of July, and we'll be interested to learn your point of view about the things I've mentioned. These are quite serious issues. They should be discussed. And the last point that I'd like to mention, the one before the last, is a serious point. It's related with carrying out of PPP projects on behalf of the private partner. It's more than one organization. In the majority of carried out projects, it's a financial body, the operator that has knowledge and skills, and quite often it's the building company or some other company that brings in some additional skills and knowledge necessary for the project. Especially if these are comprehensive projects, set of pre-qualification or qualification requirements is rather big, and quite often one organization cannot satisfy all these requirements. That's why we need more than the laws on concession. The law on PPP, from our point of view, should be much more flexible in this regard, and it should allow the participation in the tender of a union of legal entities that will enable some to unite some qualifications, and thus it's possible to transfer the rights to a special company organized by those entities at the stage of carrying out, because it's all usually carried out through a certain project or design organization. And if you don't know yet whether you won the tender or not, there's a big number of claimants, then it's not so possible for them to organize a design company. So quite often design companies are organized later on when parties have won the tender. Now they have to switch to solving of certain concrete things, thus they need to form a company that will carry out the project. And the last point, that's regarding the public partner. Since the property structure of many objects is rather comprehensive and the system of relations is comprehensive, on behalf of the public partner, there may be or should be several organizations as well. In concession agreements, concessions limit this opportunity, and PPP law should make it possible. So here are the main points regarding new legislation on PPP. great importance is that the fact that the law is already adopted in the first reading, thus the concept approach is okay and it satisfies the demands of both the market and the state. We do hope that modifications shall make it even more effective and more suitable for private clients. But if we are realistic, we'll understand in Russia there are thousands of kilometers of roads, lots of infrastructures that need to be improved. No matter how good are the state resources and finances and professional resources, we understand that the state alone cannot solve all these questions. And PPP is not the only response to all the problems and questions. We believe PPP is one of the tools, one of the ways of solution of the problems that were accumulated in the country. So if we speak about the legislation and carrying out of PPP projects in Russia, let me underline in the end. Legislation on PPP and system of PPP in Russia is not the response to all the questions. It's one of the solutions, one of the responses that I believe shall simplify greatly the attraction of private capital for the carrying out of big projects. That's the way it should be understood in Russia. Thank you. Thank you very much. Thank you, Vlad, for such a detailed presentation. You've told practically everything about the legislation. As for your last phrase that PPP is not a panacea, let me give the floor to Albert Aganyan. He's from the company Vegas Lex, famous for the fact that it's following many infrastructural projects. So I'd like to ask Albert, is your opinion the same? Do you think that PPP is one of the tools and infrastructural projects may be structured and carried out following other different schemes? And what kind of benefits and drawbacks do they have? What's your assessment of the modern trend of PPP legislation development? Thank you very much. I was thirsty, but I didn't detect which glass is mine, so all right. Dry mouth, but I will give you a brief answer to all the three questions. Yes, there are other tools. We have prospects. Do we have prospects for alternatives to PPP? The answer is probably not. Say, hospitals visited by our parents and the service that we see. We don't want to drive along the roads that we have. We don't want to use the regional airports that we have. It's all in a pitiful condition. If we want all this to remain as it is, then we shouldn't deal with PPP. If we really want to modify something, then PPP is necessary. All of you have been to Great Britain, besides those who didn't pay the fines for violating the traffic rules, those who were not allowed to go abroad. Great Britain, with its well-developed infrastructure till the year before the last, in their internal market, had, say, 900 internal infrastructure projects per year. Now let's see Russian statistics. If you calculate everything, not making difference between PP and nearly PPP projects, and add the infrastructural projects financed only privately, so on a big scale, there's 120 projects in 5 years. You understand the difference. The market is obvious. Vlad is a well-known expert at the market, and I do agree with everything he mentioned. But now let's think, why do we need it? We're all lawyers, aren't we? Some are exterior, some are interior participants, but we should understand where's business. What is any PPP project? 30% is finances and investment. That's the work for banks, investment, financial sponsors. 30% is politics, because certain infrastructural projects carried out in PPP projects may be stopped for political reasons. Such things do happen. If somebody under or overestimates his opportunities. There's the party, the state, which doesn't always take reasonable decisions on the startup of the project. And the other 30% is legislation and lawyers' work. So there's plenty of work for lawyers. And some more 10% is, well, it depends on chance, since some projects that are obviously necessary still cannot be carried out. So the lawyers present here believe that PPP projects have found their financial sponsors and investment bankers, have found the support of the authorities. Here comes the part of legal work. And for the last 2 years, the professionals are discussing what is PPP legislation. Is there such a separate sphere of economic relations as PPP? What branches, what legislation is used, and whether PPP is just a concession or whether other forms exist? Vladislav described it in detail. So those remaining 30%, which is our sphere of responsibility, I have 15 years of experience of being a lawyer. I have never seen a more sophisticated legal structure than big PPP projects. Any field of legislation, if you take budget legislation, what's to be done when we get out of that one-year term of budget planning? What should be done to the entity and federal guarantees? What relations with banks are existing in case of state guarantees? How can traffic be guaranteed in the format of concession legislation, or are there any other alternatives for guaranteeing of the traffic? But the guarantee of the traffic is the term used not only for roads, but it's also the number of people served by a certain hospital or children in the kindergarten. It's all the guarantee of traffic. If we have the topic of nursery schools, then how can we build a new real estate object? Here we have legislation regarding real estate and construction. Let's get back to the construction of that kindergarten. After you build the shell of the building, you find out that to build a kindergarten, initially it has to be built as a kindergarten, but you can't do it since in future it shall be operated by a municipal body, and the tender may be won only by a Russian entity. It's a limitation of concession limitations. It's also because of some certain medical standards that are used at construction of kindergartens. Now, a speed railroad. For 10 years, we keep saying that we shall have a high-speed railroad, but it's not existing yet. Surprisingly enough, it's the only reason for that is that lawyers don't understand how to do it. There are people willing to finance. There's the political will of the state, but lawyers cannot invent the way to carry it out. There's practically no sphere of legislation that is suitable for PPP projects. I mean, the wide understanding, wide range of the word PPP, that's sport, medicine, transportation, local and thoroughfare transport objects, whatever. There's no part of legislation that is not used in structuring of the big PPP projects. You have to be an expert in this field to do it well, but those who are experts, for them, the market of 100 and 120 projects in 5 years is too little. Actually, thousands of projects should be at the market annually. The market is potentially huge for those who become experts in future. Some $2 trillion should be invested before the year 2020 to achieve the level of Portugal. You feel insulted when you're compared to Portugal, but nevertheless, that's regarding the roads only. No, it's not only in the roads, but nevertheless, your correction is right. Without considering the natural monopolies expenses, without electricity, which is provided by the energy company, central energy company, etc. We have law number 115 on concessions. And people think that if you just read this law, you have the expert on concessions. I don't want to demotivate anyone, but it's incorrect. Law 115, well, everyone should know it, to understand that at carrying out of any concession project is just the top of the pyramid. Yet under it, there's the legislation on real estate, city construction, civil code, etc. In law number 115, it says that concession agreement is a comprehensive agreement that is based on the law 115. That draft that passed the first reading, Vlad described it in detail, so I will not describe its legal aspects. It opens the market even better for carrying out of the infrastructural projects of smaller size than the projects suitable for the law on concessions. This will have even more work, but it will be a pyramid like in the case on 115. So the law on PPP is also the top of the iceberg with many branches of legislation that are involved as well besides it. So all this may be carried out via the concession. Now regarding the first reading, everybody was trying to follow the example of St. Petersburg to be able to carry out the regional PPP projects. All the governors, and I've talked to many of them, somehow decided that it's enough to take the law of St. Petersburg and then to conduct a serious legal exercise that is called copy-paste, just replace the name of the entity, and then you'll have as many investment projects and money will come. Lots of money shall be invested. Some 30 regions have conducted this sophisticated intellectual exercise, but it's only in St. Petersburg that the projects were started for a simple reason. Since lawyers do depend on those 30% institutional financial sponsors and decisions of the authorities of Russian entities. They should understand that the pipeline, the list of projects for which the PPP project is law is adopted. First, there appears a project, and then legislation comes. Nowhere besides St. Petersburg pipeline was ahead. In all the regions, the legal form was ahead. And if legal form comes ahead of economic essence, it's resultless. Now let's get back to what was mentioned by Vlad, 900 positions or items in the risk matrix. It's not that much. Sometimes it's more. Frequently, it's more than 900. Here comes the question. When we talk about risk distribution between different parties of project, what legislation underlies? The answer is the same. We have the federal and regional PPP laws, the loan concessions. The airports are carrying out PPP projects without basing on concession legislation, and they have success. We do have successful examples in our country. We have toll roads in Russia that were conducted or created in PPP projects. They're not visible on the federal level, but nevertheless they exist in Russian entities, in provinces. I've been talking at the medical forum, and I pulled out a pill and asked the lawyers, what's the ratio of expenses on lawyers in the price of that pill? 1/4 or 1/5 of the price of the pill is expenses on lawyers. Unfortunately, in PPP projects, it's not so. The expenses on lawyers are manifold smaller. But when we talk about the general price, the total price of the project, it's sufficient money to get many lawyers involved in the work on this project, and they're quite enthusiastic working for this money. Now, getting back to the risk matrix topic, we all imagine what the classical project financing looks like. It's usually a huge sheet of paper of A1 format with many schemes of SPV, SPK, transfer of assets, bails, securities, etc. Any PPP scheme looks the same. It's a very sophisticated scheme of financing. It's never simple. Some 8 years ago in our country, there were projects financed by the investment fund, and they had relatively simpler schemes. But again, they're relatively simple. Not many simpler projects were actually carried out. Otherwise, financing is a very difficult, sophisticated scheme with plenty of legal work. And the mentioned PPP law, law on concessions, etc. If you have any current suggestions, or if after studying the materials you will have some additional suggestions on what could be integrated and added to the next modifications on the law, in the law on concessions, or what could be included in the law on PPP, which is being adopted now, please do write to me and my colleagues, because we're dealing with this issue and we participate in creation of that law, and some valuable remarks may really be taken into consideration. As for the position of different participants, I'm now dealing with advertising of PPP projects for lawyers. Although there's a great need and demand in the country for development of infrastructure, and we understand there are only two ways of financing, budget and non-budget. In 10 years, we've learned how much the budget may build, so the only solution is non-budget financing. For that, we need private operators, we need initiators of the projects, so we need financial sponsors, a big number of structures that is an industry at any Western market. We do not have such industry, neither among lawyers nor among the investment banks. We don't have such an industry formed among private operators and all the other necessary stakeholders. This doesn't mean that they're absent, that there are no majors. Of course, they do exist in any field, but majors are like islands in a big lake. And when working on PPP projects, everyone will encounter the misunderstanding of the other stakeholders that should be dealing with carrying out of these projects. And I don't think this situation will improve in the next 3 or 5 or 10 years. I don't think there'll become more stakeholders. Next, exists a big number of questions, like, let me, the prepared PPP/infrastructure project, and what's the difference of the views of financial sponsors? What's the mechanism? And whether the authorities of different levels have correct understanding of situation or not? Why doesn't it work always with legal techniques, and why doesn't it work at the level of different branches of legislation? If we think of all that, here comes the following. As soon as at the market there appears a more or less clear and prepared by lawyers as well, investment people as well, by the region or by the federal authorities or municipalities project, then if the project is prepared, there's a line of those who want to participate in it. So more or less well-prepared projects are very popular. I believe my colleagues will agree with my opinion. That's it. Thank you very much, Albert. Thank you for this personal attitude about this acute topic, and your last saying that there are not enough projects that may be financed. As a banker, I agree with you. There is money and there is a desire to invest in infrastructural projects because we understand these are long-term projects and everybody needs that. Consumers need that, but there are no projects, no understanding on how they should be structured, what should they begin with, what substantiation should be prepared for them, and what is necessary for all the financial bodies to be ready to invest their money. We're talking about childhood diseases of PPP. Now let me give the floor to Sophie Robinson from Great Britain. Sophie is from the company Eversheds, and I'd like to ask her a question. How do you in Great Britain manage to have 900 projects a year, considering the fact that these are not the British projects, but projects which, with the help of your experience and with the help of common law that you are exporting to different countries, appear in other countries as well, including Africa and God knows where. Sophia, welcome.
Thank you. As I say, my expertise extends not only to infrastructure projects and PPP projects in the UK, but also in North Africa and the Middle East. I'm going to draw on all of those jurisdictions in my presentation. So to start with, why would you use a PPP legislation? In the UK, there's no specific PPP law, but as a common law jurisdiction, there's a lot of flexibility about how infrastructure projects can be procured, how the public sector engages with the private sector to bring that expertise and that investment to the services and works that are procured. Nevertheless, we have a lot of sector-by-sector guidance and regulation that supplements that common law, and which it makes it very clear to bidders and to investors what it is that the public sector is looking for and how that's procured. The EU procurement rules also sit above the common law system in the UK, giving that structure and again that framework. So there's lots that does facilitate PPP, even though there's not a specific law that you can point to. However, as we all know, the structure of PPPs can be very complex, and in a civil law jurisdiction, there can be a number of restrictions on a procurement process and a number of obstacles that means that it makes sense to implement a formal PPP law. And this is something that we've helped with and looked at in developing countries, also in the Middle East, in Egypt, where they've implemented a specific PPP law. One of the most obvious advantages is that it can supplement and override those obstacles and those restrictive procurement processes. Often they're aimed at one-off procurements of goods or services and not looked at long-term partnerships. The evaluation processes can require that the lowest price wins, for example, which then doesn't bring that expertise that you're looking for in a public-private partnership. One of the most difficult elements that we found with codified systems is that it doesn't allow the engagement with bidders that the public sector would like. If one of the main purposes of a PPP is to bring that expertise and that private sector view on things, then that procurement process is incredibly important in bringing that expertise. Other examples of restrictions in a civil law jurisdiction can be restrictions on the currency that are used to bid, the dispute resolution procedures that must be followed, which may be inappropriate, and they may advantage local suppliers. So in Egypt, for example, it used to be the case that a local supplier bidding for a project would get a 15% uplift on their price as a sort of incentive to bid, but that, of course, restricted international competition and international investment into the country. Other obstacles that might mean that a PPP legislation makes sense, a lack of clarity in local legislation. Again, in Egypt, the supply of drinkable water was thought to be reserved to the government, and that the legislation was unclear on that. But it meant that they felt unable to do a PPP on that and bring a private sector in to do a potable water project until a PPP legislation had been passed. There may be precedents as well. So in the Middle East, there were quite a lot of early laws about bringing a PPP project to the power sector. That delivered lots of successful projects, but it meant that when those jurisdictions were going out for more accommodation-based schemes, so schools or hospitals, bidders and investors would query why there had been a law for one sector, but not for the other sectors, and so it makes sense to have a consistent approach. PPP laws have also helped bring both impetus and a centre of expertise to the region. So if you have a specific PPP law, it's often coupled with a specific bureau or a ministry responsible for those projects. It gives a sense of accountability, and it means that there is capacity building and capability in the country, which again gives confidence to the market. And it can help appoint advisors as well, who will be experienced in PPP and have the skills and experience to get projects across the line. Most importantly, just at the bottom of the slide there, a PPP law can give sort of guarantees and protection to investors to give them confidence to invest and give compliance with IFI requirements and bring those investments to the country. So what should a PPP law cover? Much of this is enshrined in the law of St. Petersburg and the wider federal law, but it basically establishes the PPP concept, and it can give a definition of scope as well. PPP can mean many different things to different people, and it's helpful to understand what a particular country and jurisdiction means by the concept. It can govern the size, scope, length of contract, and it can help overcome some of those obstacles in the civil law jurisdiction that might preclude investment. It can also put in place a clear approvals process for a project, both at the outset when it's being developed and also at the end when you're signing it off. That gives the procuring authority certainty that they know what they're doing and it will go ahead, and again gives the market confidence that they can invest. Again, establishment of a centre of expertise. The main element of the procurement rules might be around the procurement process. It can allow interaction with bidders, an ability to test the market, to speak to the markets about what the most attractive project is, and also introduce a more sophisticated evaluation process. So you're not just looking at the lowest price, but you're looking at what quality you're getting for that price and what other options might be available. You can also set out some core contracting principles, and again, talked earlier about land and labour issues that if they're sorted in a single codified law, then bidders don't have to be concerned about those. It reduces the negotiation time and it makes investments that much easier. You can also address the governing law issues in the PPP law, and in particular might want to introduce an allowance for international arbitration or something else that works on a more international basis. So to summarise the advantages and some of the disadvantages, the advantages are that it shows a level of government commitment and support. Understandably, a law wouldn't have been passed unless the government was committed to a pipeline of PPP projects. I think that's what's trying to be established here with the new amendments and the new law. It's trying to get that impetus into the infrastructure market and to develop that next step of projects. It provides a transparent and flexible process to get you across the line and not only have a pipeline of projects, but ones that are successfully being delivered and doing what they're meant to be doing. It gives confidence to investors and generally ensures that there'll be funding in place and ring-fenced, especially for the initial projects. If a government's passed a PPP law, then ordinarily it means that there's that commitment there and that funding ready to go. So what are the things to look out for? And these are some of the things that need to be thought about here now. It can take time for a PPP law to be brought into place. If there's disquiet in the country about private investment in public services, it might be used as a reason to bring that protest to the fore. If it's not done comprehensively, laws can be poorly drafted. It's important to look at the civil law jurisdiction and ensure that every element of all those obstacles to PPP that have been identified are addressed and are addressed in a way that's going to be acceptable to the market. That can stop again, long procurement processes and having to go back and do it again. it's also important to understand that, as well as having a specific law and a PPP programme and pipeline, that the capability and capacity and momentum is built into the country as well, and that all those things are brought together and are moving together towards that common goal for the infrastructure that's going to be delivered. And I guess the final thing just to remember is that having a formal PPP law doesn't necessarily prevent legal challenges. There are still bidders and investors who will come and invest in the country, but it's never a straightforward process, and PPPs are complex, and those difficulties can still remain. So just to summarise, drawn on a few different examples, the UK doesn't have a formal PPP system, but is underpinned by a number of bits of legislation and guidance. Russia is going through the process now of that codification process. I think Egypt is a good example of a jurisdiction we've worked in that has codified their law, and it was really getting some momentum going with their PPP programme. I think political and economic events have taken over, but they very much structured their PPP law to be attractive to bidders, and the amendments that they made and the changes in that law kept coming back to what do investors want and what does the market want, which ultimately gave a sort of successful project. Thank you.
Thank you very much, Sophie. Quite an unexpected thing. We all thought that Great Britain, being the leader of PPP projects, shall talk only about the benefits of their legal system, which doesn't have a formal law on PPP like we're trying to create. But nevertheless, Sophie found some benefits in our approach, and that PPP law shouldn't be over-regulated. Now I have a question to the representatives of business, to the representative of a leader managing company, Madam Larissa Mityaeva. If there's no PPP law yet in Russia, just the law on concession, how do you nevertheless manage to finance PPP projects? And what do you think about the prospects of PPP projects development in Russia? Thank you, Alexei. Let me greet all the esteemed colleagues. I'm happy that on such a sunny day you've preferred to be in this hall, and that this topic is of interest for you, as it is for us. That PPP law is an issue which is being discussed for quite a number of years, several years. Investors are worried about this issue as well. They're concerned. We carry out both regional and federal PPP projects, some 11 projects all over the country. We're quite proud to be a big stakeholder in the field of PPP projects. Though in the regions of Russia, PPP laws exist, in all our regional projects, we were guided by the law number 115, always. Whether it's good or bad, perhaps it's good, since we could nevertheless carry out these projects, and it is probably also partly bad, because some of the mechanisms that we could have used were unavailable, unlike the opportunities, say, in the West, and in comparison with the ideas stated by Vladislav today. We didn't have such an opportunity. But we were looking at what's in the minds of the developers of the law on concessions and the law on PPP. When getting ready for my speech today, I was planning to say things that Vladislav has already mentioned, and I was planning to mention not only the benefits but the drawbacks of the project as well, that it needs to be finished. In general, the adoption of such a draft law is a positive thing. It's a great thing. We're happy that it is happening. And things that should be criticized, well, first of all, criticizing is better than finding positive features. It's easy to criticize, and many things may be criticized. Not only us, but also the exterior experts are still criticizing the draft law, but some positive things are obvious as well. I could explain them in more detail if I have the time. I have a question to the moderator. Do I have time for that? Just the main points, please, without explanation why and how. Yes, sure. Please give me the remote control. Thank you. May I have my presentation? Thank you. Thanks to Vladislav, and due to the lack of time, I'll start from slide number 13 of my presentation. Here, about the purpose of adoption of this draft law. These are positive reasons: to remove limitations, to improve financing, to make uniform legislation, to get rid of contradictions. I believe that these goals are already partially achieved. We may think just about the future perfection of this text. I did mention the benefits. Sorry, the characters are too small, so don't read, do listen to me. It's important that we understand the necessity of modifications, and not only the PPP law should be adopted, but some industry laws that regulate this field as well. It regulates modification of some laws within the project. Maybe it should be outside its regulation. Perhaps it would be better to modify laws separately, the industry laws, the land code, the tax code, the separate laws. But that's more regarding the technology of the process. Other forms of PPP besides the concession are good to have, but we would like to see a list of forms that had been not closed but open. We should understand the trends so that people who adopt this law should understand that besides PPP and concession, for those who are dealing with PPP understand it, but those who do not understand this yet. They just want to structure their deal. It's not quite clear for them which form to use. I believe Albert will agree with me about it. Albert's words can't be heard. Yes, for them especially. The things that were absent before in the law on concessions do appear, like, for example, the full reimbursement of losses for the partner. We all read the civil code, and we know that this right is also mentioned there, but when we speak about reimbursement of lost missed profit, it's not mentioned in the law on concessions. As for the three-party agreement, yes, it's mentioned in the draft law, but the way it looks in the West, step-in rights, direct management of financing organizations, we don't have that on this level. This draft law hasn't achieved that level yet. This regularization is very important, as Vladislav mentioned, for foreign investors, and we want this issue to be more detailed in this next second reading. Interesting thing regarding Article 11 of the draft law. Here in Syria, I see a possibility of a separate tender for operation of the PPP object. Concessions law doesn't give such an opportunity, and in principle, we believe that the PPP typology, the common one, doesn't let us have such a model. We always first create something before we operate it. It's logical. If we operate something after we create it, we are interested to do it correctly, with high quality. But if we talk about the project Freedom 1 that we've carried out, now we do that construction of a part of the toll road between Moscow and Minsk. The operation is the kind of activity on such a big, sophisticated object, such a big road. It had so many challenges in it. There was an idea on whether it's possible to have a separate tender for operation. The answer was once negative, and legislation didn't give us such an opportunity. We were explained in such a way. Now, coming back to the text of this article, we may ask ourselves, let me ask it to Vladislav, maybe there is such an opportunity, and perhaps the developer of the draft law could give us such an opportunity. Now, about the drawbacks of the draft law, I'll be brief. Of course, terminology is not quite finished. There are some contradictions inside the law, draft law, and contradictions between this draft law and the law on concessions, but they may be eliminated. Now, regarding the absence of different forms of PPP, kinds of PPP, I should also mention municipalities. They have high interest for PPPs, and they say we really need it for the reasons mentioned by Albert. Bad roads, no good hospitals, the infrastructure is in a pitiful condition. So, according to the comments given by the different committees of the Duma, Russian Parliament, municipalities are not part of the central authorities. Thus, formally, they cannot be part of such partnerships. For them, a separate status needs to be formed, municipal private partnership, MPP. Is that possible? I believe there's reasons behind these considerations, and such contradictions should be eliminated at an early stage. Otherwise, we may have serious problems, like municipalities won't be able to use the legislation adopted. Now, about the guarantees, they can't be provided on the level of municipalities. They need to the federal entities to give the guarantees. Independent control as the form of control is not in this draft law, while experience on PPP, especially with participation of foreign partners, tells that such problem exists. Foreign partners do want to have such an independent figure in the projects. Let me give you a brief example of a project we've participated in when we came to the public partner, and we said that we want to have an independent engineer, and we wanted to share the expenses on the engineer between the public and private partner. They said yes, they're okay about that engineer, but we, the private partner, should pay for it. So thus the idea was killed. The possibility of mediation is not provided. We should think about it already now, considering the fact that many investors abroad want to have an opportunity of arbitrage with the public partner. Now it's not provided unless the public partner is okay about it in the Chamber of Commerce and Industry of the Russian Federation, the arbitrary court, the arbitrary considerations. Well, there are some certain drawbacks that should be corrected while preparing it for the second reading. Possibilities for corruption. It's possible to have corruption since not everything is transparent enough or detailed enough. I may continue my list, but let me tell you the following. We should still congratulate the lawyers on the fact that this was already done. And as Albert mentioned, we should actively participate in finishing of this project, in improving it, and let us bring the ideas from our heads into that project. Thank you very much for the attention. Now I found my glass. I drank some water. I have several questions to you. Question number one, if you let me. What if we put aside the PPP draft law? From your speech, I understood that the team of authors should be fired. Now, regarding the draft law, I know that you are dealing with it for at least 4 or 5 years. I mean, in carrying out and structuring of different projects. From the legal point of view, what key changes have taken place? That's my question number one. Legislation hasn't changed a lot. We remember that. But the practice has changed a lot. That's my first question. And in my question, there's a sub-question that is regarding the infrastructural bonds. It's a topic that everyone is concerned about. That's because for at least 4 years, this issue is being discussed. There are two approaches to infrastructural bonds. At the market, the optimal thing is not to make infrastructural bonds on behalf of natural monopolies. I'm for it. Then legislation needn't be modified. There'll be 5 or 6 issues of infrastructural bonds, and that doesn't provide much work for lawyers. That's okay. There's another approach. That's if infrastructural bond is for the average projects, and there may be hundreds of them at the market. In that case, legislation is not changed. Now it's the peak of discussions at the moment. But beforehand, for M1 project, you've done what was called the infrastructural bonds, I believe. So this is my sub-question about the infrastructural bonds, whether the situation is modified in this field. That's it. Thank you for your questions, Albert. I'll begin with the first question regarding the legislation modification. They did take place. Law number 115, there were some modifications in the regions. They kept adopting PPP laws, and now we've come to the basic PPP law adoption on the federal level. Whether it should exist or not, if we compare with the situation in Great Britain, where they do not have such a law. What's the impetus of forming of PPP institution? If it's formed from above, if it's done by force, such a law, yes, we do need it, coming from above. The other question is, why didn't we have it before the year 2005, when the law on concessions was adopted? The process of forming of modifications and of existing legislation were a bit not orderly, but nevertheless we are forming this system, and modifications of legislation that already took place were kind of for elimination of existing contradictions in legal practice. When we encounter the problem, we modify legislation. That's the way it happened. That's how I assess the modifications of legislation. As for the adoption of new law, with the help of Vladislav and his colleagues, the situation will change and we shall obtain a more civilized approach. We shall not solve problems when they arise, but we shall have prevention of problems. Did I answer your question? I will switch to the next sub-question about infrastructural bonds. Well, we do use this mechanism. But it should be understood that as a managing company, we are subject to many regulations, and quite often we aren't able to use the market investment tools that our colleagues may use. For us, the infrastructural bonds are an interesting tool, Frankly speaking, I'm in between the first and the second approach. It's not quite clear whether this mechanism may become market mechanism and how usable it shall be for the average segment of investors. Can't answer yet. Considering the requirements to the issuing, I'm not sure. But in principle, such a tool is possible. Why not? So we should consider on how to make it usable for the average segment. But if you say you don't want to modify legislation, well, unfortunately, our legislation needs to be modified, not only in the field of PPP. You can't do without it. Brief question, just to mark the problem for all the people present here. What if there's a raid on behalf on anti-monopoly service is a success? Do you think the market of PPP projects shall be benefited by that, or is it bad for it, or it's no reaction? I can't say yes or no. You have only three options: plus, minus, or no influence. Neither. I'm between yes and no. Can't give you an answer. Maybe it's not a benefit, but it's not a minus as well. I don't think that PPP, you shouldn't deal with PPP anymore after that. It's stupid to ask questions to yourself, but please do ask me this question later on, as we should have formed a test and disseminated it and then present the results on the table. Vote about it. Thank you very much for very detailed answers to our questions. You are one of the small number of investors that did issue bonds and place them, and you finance projects. Just the things you do in Nizhny Novgorod are great, and the leaders prove that it's possible to use this tool. So you are the leader in the field of financing of infrastructural projects. Answering to the question that you have asked about the year 2005, why didn't we adopt a PPP law then, but instead a law on concessions? I do remember very well how it was adopted when the Ministry of Economic Development was pushing that project and believed it's a solution to all the non-budget financing of infrastructure. Remember what we've had in the year 2005, the agreement of rent on invest conditions, which is still considered to be like a gray scheme, nothing else. So when the loan concessions was adopted, it was quite innovative for private investors at that time in infrastructure. Long-term liabilities between business and state, what else can you wish? And only now we understood that there are too little concession contracts that were actually carried out in Russia. Since concession mechanisms are over-regulated and it impedes the development of average regional PPP projects. Now let me give the floor to Mr. Alexei Zverev, the chief lawyer of European Bank of Reconstruction and Development. I have a question to him. Well, EBRD is financing many projects, not in Russia only, but in other countries as well. What's your opinion, since you're a financial body? What is your opinion on the prospects of EBRD investments in Russian infrastructure? The projects are here, but you can't invest, or there are no projects, so it's not an interesting topic, or perhaps there's money and there are projects, but the projects are prepared badly, and your credit committees can't approve those projects. Good day. Thank you, Alexei, for the question. I'm tempted to give a brief answer. There's money, but there's no projects. I will probably agree with your last statement that projects are prepared in a bad way and legislation is far from being perfect. There are other reasons as well. In fact, the PPP topic is closely related to the legal policy, and to prove this statement, I'd like to talk about the legal trends. And after a detailed explanation of the problems that practitioners experience at the level of projects, investments, negotiations, let us get to see it from a distance, from a certain height, and see in what world do we live regarding the development of PPP legislation. When making a research on behalf of EBRD on all the countries, and there are more than 30 countries where EBRD operates, lately I managed to discover a number of trends. One of these trends proves that in the last 4 or 5 years, the legislation or legislation activity of different countries in the field of PPP regulation has sufficiently improved. It really grew sufficiently. In the last 4 years, 19 of those countries have modified the laws at least, and half of those countries have adopted new laws. The next trend is regulation of PPP, direct regulation, in comparison with what was happening before. Before, it was on the national level, on the level of legislation, and via concessions. The PPP is regulated. Actually, the legal notion of PPP is being regulated until the middle of the last decade. It was only done in a small number of countries, no more than 10 countries. And since the year 2004, they started to grow the number of countries with PPP regulation and not just the concession agreements. The reason for that is a different issue. We could talk about it. I believe it's caused by the fact that in the year 2005, the European Commission has published the results of the Green Book on PPP, the results of negotiations and discussions, and in November of the year 2005, there was made a conclusion that European Commission refuses from direct regulation on the level of directives of the PPPs. According to the opinion of the Commission, PPP is either a public contract or a concession agreement. Both may be regulated, so why to regulate something third? So I believe that was one of the impulses, and thus countries started to regulate PPP on the national level, and thus the laws and determinations of PPP were adopted. Laws are very different, by the way, since legislation is different in different countries. It's very different. It's between 2 and 60 pages, etc. The next trend related to the difference in legislative regulations. More frequently, not quite frequently, but more frequently, there appears the institutional regulation of PPP. Before, contractual forms were being regulated. Now, the institutional forms are regulated as well. The other trend is related to regulation of such of such a thing that in Britain it's called Private Finance Initiative. That is, speaking simply, it's financial of the social sector of infrastructure without transferring of the functions of servicing. Say, education, you build an object and build a school or a kindergarten, but the tuition functions are not included. Or healthcare, same functions. Just construction or modernization or refurbishing of the building of the hospital, but without the transfer to the private sector of the function of medical services. The other trend is being practical. The legislators in countries are now practical about regulation of PPP, especially after the year 2008, after the crisis. There is some competition for attraction of private investments. Vladislav did mention that the PPP projects are structured mainly as ways or methods of project financing. That means some 60, 70, 80% of financing is attracted capital. Thus, investors should feel comfortable. Creditors' comfort is of vital importance, and if there's no such comfort, the projects get more expensive. And one more last trend that we witnessed during the last decade, there takes place the growth of institutional infrastructural centers that are dealing with PPP to a certain extent, playing certain roles. PPP centers may have different functions and roles, but in many countries they also do the operational works. Getting back to my first thesis statement that PPP is closely connected with legal policy, I should also mention, perhaps not a trend yet, and I hope it will not become a trend, but there is such a phenomena. Some countries are reviewing their legal policy regarding PPP. And the Great Britain, which was mentioned today, after 20 years of successful work, it was the institutional pillar of PPP organization. I mean PUK, Partnership UK. That pillar was stopped its existence and its functions were handed over to other bodies. So they're reviewing their legal policy in the field of PPP. So does France. And last year, Hungary joined these countries. I should explain the situation in Hungary in more detail if I have a minute. The point is that if we look at our neighbors, Hungary probably has the biggest experience in this field, both positive and negative, which is precious. Since negative experience, mistakes of Hungarian PPPs are a good lesson for us. Positive experience is a good lesson as well. And the new government in Hungary announced the closing of PPP programs. Moreover, they announced that all the current PPP programs and projects shall be reviewed with the purpose of closing them, and that they will be purchased back by the public sector. I wouldn't say it's a trend. It's a phenomenon of that country, but it should be paid attention to. Getting back to Russia. In fact, I do agree, of course, with what was mentioned before me. PPP is a great potential opportunity for effective attraction of financial, managerial, and technological resources for solution of socially important tasks in the field of infrastructure. And if we single out the best sides of PPP, I would mention three. That's financial efficiency of invested funds, which was the most important thing when Blair, in the year 1997, inherited this program from the Conservative Party. And by the way, in the year 1992, since we're talking about it, maybe Sofia will correct me if I'm wrong, but in the year 1992, when the PPP program, PFI, was started in Great Britain, it had absolutely different tasks. Goals were different. It wasn't value for money, not financial efficiency of invested money, but the main target was bringing down of the debt liabilities of the budget, debt load on the budget. But when Labour government inherited this program, they have just modified the goals and the approach, but they continue the program. As for the financial efficiency of invested money, yeah, there's no debt load on the budget, which is a benefit, and you keep controlling the quality of services and works. It should be noted that disregarding the positive trends of development of legislation on PPP and concessions in Russia, at present there remains a number of positions and principles that impede the successful usage of PPP mechanism or tool, and unfortunately neither of the three advantages is provided completely by the norms of Russian legislation. For us to solve the problems that were mentioned today in great detail, the budget, land, provision tariff, arbitrary issues, we need a long-term conceptual understanding and modifications and additions to the concession legislation that took place since the year 2005, and they tend to be annual, at least on some years. If you trace the history, you will see there were more than one modification per year. On some years, modification of legislation on concessions took place several times a year. And this fact testifies that there's no thoroughly thought concept of the main principles of PPP support. I'm not sure if I really answered your question set by Alexei, but at least I've tried to. And the last point that I'd like to mention is about the work of EBRD. Everybody knows that EBRD is the biggest investor in Russia, not in Russia, only in most of the countries where it operates. But besides the investment activity, we also support a lot the work on formulation of the legal policy. We assist the legal dialogue with the authorities in certain fields, in particular in the development of infrastructural projects and regulation of PPP. And those who did read the explanatory note to the new draft law on PPP probably paid attention to the fact that this provided the development by the Ministry of Economic Development of a number of guidelines and instructions. And I'm happy about the fact that 4 of those guidelines will be prepared by us together in cooperation with the Ministry on Economic Development. So EBRD will participate in that. That's a guideline on preparation on the position of the tender, on preparation of the agreement, and the development of the risk metrics and the metrics of financial efficiency of the projects, and the key indicators of PPP projects efficiency. And the last point, on the site of EBRD, you will find the links to the explanations about our work if you enter www.ebrd.com/concessions. You're welcome. Thank you. Thank you very much. You know, I have a question. Since we are all lawyers here and we talk about the actual things, it's probably bad to talk about yourself if you are the member of the panel. But this doesn't refer to our colleagues from EBRD. What about the World Bank when it says how good it is? You feel offended because if you start saying how good you are, it looks like advertising. But when the World Bank does it, it's as if it's the way it should be. Nevertheless, I'm concerned that EBRD shall help the Ministry of Economic Development to prepare 4 of the 5 guidelines. I'm concerned because of the following reasons. First of all, it's a question to Alexei as well. The first question is as follows: whether EBRD does support the expansion of usable law. Should we get wider than just Russian legislation if it's an international project? The second is the clause. What wasn't included in the law on concessions, the things we were fighting about in the year 2000, whether there should be an arbitrary clause and whether foreign arbitrary tribunals may be involved. And the third, not a question but a comment regarding the position of Hungary and what's happening in Hungary at the moment. Please pay attention to the fact. Correct me if I'm wrong, Alexei, but as far as I understand, a number of years ago, a couple of years ago, the Hungarian Zhirinovsky came to power, a kind of Zhirinovsky, and that's why they're revising this topic, not because PPP and concessions are not efficient, but because the market was too open for foreign investors and very many important national infrastructures of strategic importance have too much of foreign capital in them. That is why they are not closing PPPs totally and concession projects totally, but they want to make kind of a serious revision of the fields that are of a strategic importance for the country. And when you answer the questions number 1 and number 2, what do you do with that clause, especially considering the fact that yesterday the President spoke about its correction regarding two-party agreements about the protection and promotion of capital investment. In it, there was a tool on how to deal with international contracts. As for the arbitrary tribunal ad hoc, how the disputes are to be resolved with participation of the state of Russia, and why it wasn't sufficient before when the law on concessions was formed. This tool seems to protect very well. It's probably more lengthy, but it does protect the interests of Russian or foreign investors in case of violation of that clause. I would have united those two issues. The first two questions As for the usable law and arbitrary clause, my position is simple. I always recommend the governments that I consult
to include a possibility of the application of any law, including international law. As for the arbitration caveat, of course, international arbitration should be included when the Ministry of Justice objects to it. I would say that usually 50% of the countries do not adopt it because ministries of justice say, how come? How can we give away this thing? To which I respond that your position during the negotiations on a specific project will be the same, and you may insist on the application of a specific law, applicable law, which you prefer. And the same is true with regard to the forum shopping. As a rule, it works. They do include it. They do include such possibilities in the law, but during negotiations they may change it. As for the grandfather clause, in 2003, UNCITRAL model legislative provisions were released regarding infrastructural projects funded through foreign sources. When at the working group this issue was discussed and I offered this grandfather clause to be included, they told me that you are quite lucky at EBRD, but at the United Nations we can't do it because for many countries such clauses are anti-constitutional, while you need to have unanimous voting in the United Nations. That is about the grandfather clause. And the last question to you, and a similar question to Vlad Zabrodin. You have a 10-point score scale. Well, 0, nothing, 10, yes, we will have a foreign law applicable for PPPs. If my surname was not Zverev, but Mr. Glober, who is a fortune teller in our country, well known, I would have answered your question, but not now. Maybe. I don't see anything bad about it. Unfortunately, the speaker is not using the mic. If you insist, I will tell you the following. Alexei referred to 2005 and the preparation of the concession draft law. By the way, it took 10 years to discuss it. The first working group was launched in 1996, and I still remember my comments of 1998. So 2 days before the adoption of this law, we had seen an absolutely different draft law. So 1 day is enough to change everything.
I would like to somewhat rephrase the response to this question. Well, I think this will be an answer to your question. I think that the international law is already applicable there. The question is not whether or not it is applicable. The question is whether this international law will be really enforced. Will the court decisions that will be taken based on those agreements enforced in Russia? And here we need a crystal ball to understand whether it's going to work or not. But I think to a large extent this will depend on the government's position. If we need international investment, if we need international money, this is the only way to attract those funds. The first negative situation with non-fulfillment of a court decision involving a foreign party will reduce the influx of money. Well, we would like to involve you more in this discussion, but still, let us pass from regulation to more specific questions and give a word to practitioner Anna Yefimova from Mosenergo power company. The power sector is quite specific, and specific laws are at work there, and mechanisms of long-term guarantees for investments in power assets. From your standpoint, are they sufficient for the development of this important sector? Shall we invent some new mechanisms? Is there any place for DPM2? And whatever you think is important from the point of view of funding the power sector. Thank you very much. Good afternoon, dear colleagues. I'll try to be brief. Well, can I have the remote control? Well, as one of the mechanisms of long-term investment of capital in the construction of power industry facilities is currently at the implementation stage. That is conclusion of contracts for leasing capacities. Since this roundtable is not devoted specifically to the power sector, I will just say a few words. I would like just to say a few words about why we introduced a mechanism for long-term funding of electric power engineering projects. Starting from 2000s, the power sector started to be reformed. Our US was reorganized. Certain types of activity as power generation and power transmission were no longer allowed to be carried out by the private sector. And then I would like to say how it reflects today and what kind of difficulties we are faced with in the implementation of capacity leasing agreements. Power generation, the power sector has certain peculiarities which are determined by the physical nature of electricity, that is, the simultaneous nature of production and consumption, the equality in the volume of production and consumption, and there is no possibility to stockpile electricity. And there is no way to specifically predict consumption and production. Therefore, we need to maintain a lot of reserve capacity in the power sector. Also, the power sector is characterized by a very long investment cycle, both in terms of modernizing existing equipment and construction of new generating facilities. Today, earlier at the round table on power engineering, we had a discussion whether power capacity is a commodity or not. We have both the electricity market and the electricity generation capacity, where it is viewed as a commodity. So the formation of capacity market was aimed at establishing favorable conditions for attracting investment into the power sector that would lead to the establishment of new power generation capacities that would be necessary to satisfy the demand for electricity and at the same time maintain the appropriate level of reliability of electricity supply. So we had to enhance the investment attractiveness of our sector through providing long-term guarantees to our counterparts. We need to also ensure long-term reliability in order to prevent shortages in the system. At the same time, the task was set to minimize the cost of electricity and electricity generation capacities for the end users. So if we assume that the capacity is a commodity as it is today, so capacity agreements started to be emerged, whereby the producer undertakes to provide certain capacity and the consumer undertakes to pay for it. But at the same time, we're of course regulated by all the relevant norms and regulations. So the parties to such agreements are power supply companies, system operators of the wholesale market, which manages power regimes and carries out oversight over the construction of power generation capacities. There are companies who sell electricity at the wholesale market. There is also such formation as a market council, which adopts model agreements that have to be followed by all those who enter into such arrangements. So capacity agreements are only concluded with regard to the power generation facilities whose list is defined by the government of the Russian Federation. So what kind of guarantees were enshrined in those laws, in those contracts? So the duration of such contracts is 10 years. In 2010, we finished the first round of signing agreements on providing capacities. So the thermal and electricity generators have a guaranteed source of funding for the coming 10 years, which also covers the investment. So the provision of capacity envisages the mechanism for determining the price for this capacity for the entire 10-year period. Well, probably I would like to say more about certain problems that we come across. The mechanism is okay, it's an interesting approach. Generating companies are obliged to build certain facilities within a very stringent time frame. The contracts of this kind have very significant liabilities for both failure to complete the construction on time or to the failure to provide the appropriate amount of electricity to the market. The mechanism for implementation is quite interesting, but there are lots of issues that remain unresolved until now. And answering the question whether we need DPM2, yes, well, DPM2 is on the one side interesting. It helps to attract investments in the construction of power capacities, but without solving certain problems, probably DPM2 are not going to be very interesting for generating companies. There are large fines involved, and the possibilities are quite limited. What I'm trying to say is that there are only a number of cases where a generating company can waive responsibility for not complying with the time frame for the construction of the power generation facility. Generating companies and transmission companies were separated, and the generation company is not held liable only if the transmission company failed to ensure the construction of the network, the power grid or pipeline or whatever. When the government took a decision providing for stringent timelines, investment programs were not synchronized, and companies also are participating in the provision of this capacity, generation capacity. We need to provide generation capacity on the 31st December 2013, but in the grid company are planning to build a substation only in 2014. So the plans were not synchronized. And the same holds true for Mosgas, for example, the Moscow gas utility. The construction of capacities is envisioned for a particular year, but the network to which it's going to be connected is going to be built only later. Land relations are also difficult because if we have a very stringent timeline for the construction of objects, if it's a new project, a greenfield project, so the land should be allocated for this project. And there are also difficulties related to the fact that greenfield projects are usually built on the territory of existing power stations, and we cannot start the construction until we change the purpose of the use of land. So in order to start construction, we need change the purpose of the use of land from operation to construction. While taking into account all these stringent time requirements and high fines, we think that they tend to be an obstacle to the development of Russian industry. Why? We are talking about that. If we are planning to install a new turbine produced by a Russian company, but we understand that this turbine is of an experimental nature, and within such a short period of time, we understand that if at some point in time during the startup and adjustment, we understand that this turbine doesn't have the planned technical parameters for its improvement, we will need 1 year to 18 months, and the generating company doesn't have those 1.5 years to improve on this equipment. Therefore, we have to refuse to use Russian equipment and buy foreign equipment which has been tested everywhere, including Russia. This is one of the problems. Well, there are lots of problems. I can go on and on enumerating them, but probably I will stop here. The mechanism is okay, it's interesting, it is implementable, but judging from the experience of DPM-1, we understood that problems do exist. We would like to resolve them also at the legislative level, and then DPM-2 would be also a possibility. Thank you very much, Anna. You said a lot about specific features of your sector, but as a bank, I can tell you that for a bank providing finance to a generating company participating in a DPM, DPM is a guarantee for the return of investment, and everything else is, just project financing. All other financing outside the DPM scheme, everything, everything goes to the balance sheet of the company, and then you have an inappropriate balance between EBITDA and debt burden. I would like to address my question to the representative of the National Tariff Service, Mr. Stepanenko. This lack of financing that we have in the housing sector, in the power generation sector, in order to bridge this gap, are you considering within your service a possibility to introduce certain commitments for long-term tariffs for new generating facilities, be it power generation or heat generation, that need to be built in order to bridge this gap in capacities, or you see certain minuses? Why don't we still have no long-term tariff in place? Because from the point of view of financing organization, this is the most important thing, the main obstacle to financing new power sector facilities. Thank you very much. Thank you very much for your question. This problem does exist, the problem of the lack of financing, but at the same time the regulator, the legislator, they are quite restricted because they need to curb the growth of tariffs for the users, for the population primarily. I spoke about this at the power sector roundtable table already. Here we need to strike a balance between the regulator on the one hand and the investor on the other hand and the consumer on the third hand who receives certain services, and we need to ensure some economic viability that would be underpinned by social justice. Long-term tariffs setting, this mechanism is now being improved. It is being introduced in new sectors, and primarily it was quite well developed for natural monopolies, for electricity transmission grids primarily. Since 2010, according to Federal Law 35, long-term tariffs have become compulsory for electricity transmission for the national grid since 2010, since 2011 for territorial grid organizations that are going to be reorganized, and since 2012 it is compulsory for all other grid operators. Long-term tariff setting, well, it is for 5 years as a general rule, and for 3 years for the first time. There are different methods of calculating tariffs. That is the profit margin on investment, a mechanism involving indexing of tariffs. Or comparison or benchmarking is another way to set tariffs for the long term.
As for other industries, in the Federal Law 190 on power supply, and in another law on water supply, water discharge, there is a requirement to ensure long-term tariff policies starting from 2016, and there will be stage-by-stage transition to this approach of long-term tariffs. Speaking about Federal Law 416, for the first time, well, in the area of tariffs, we see a model of a regulatory agreement, which is signed between a regulatory organization and the tax entity, because tariffs are set up by the regional entities of the Russian Federation. So the agreement is signed by the authorized agency and the regulated organization. And one of the conditions of such agreements is the time. So it is signed on a long-term basis. And also there is another important new thing, is that long-term parameters are set up in these agreements. They cannot be changed during the term of this agreement. And because generally in the area of power supply, it was possible in the past to change tariffs during the term of an agreement. And so this new thing stipulates that it will be impossible to change them. And one more thing is an obligation of the regulator to consider the costs. The cost, for example, of implementation of investment programs, and also production, so capital investments, and the operational costs of these providers. Also, there's a mechanism for returning the invested funds, and long-term parameters. I mentioned them already. So, What else can we say? Speaking about this tariff regulating model, both in the area of water and power supply and in other monopoly areas, the only body that can regulate these monopolies is the state tariff authority. And the main function of identifying the amount of tariffs is a prerogative of regions, but the federal tariff policy authority, they control these tariffs. There is another interesting new mechanism. So there can be pre-court resolution of disputes. So it is not necessary to file a claim, but you can send an application to the Federal Tariff Service, and this dispute can be resolved by them. So if the applicant confirms all their costs, for example, and that in their capital investments should be included into the tariffs, then the Federal Tariff Service will send an order to the regional authority to adjust the tariff. So there is this method of dispute resolution as well. Yeah, all in all, that's it. Thank you, Ivan Grigorievich. But still, we as bankers, we say, okay, it is good that if you're not satisfied with the decision, then investors can send the application to this federal tariff service, and maybe everything will be fine. And it is good that tariffs won't be changed for 3 or 5 years. Okay, that's fine. But this doesn't attract more money into infrastructure projects, because in all these areas, you cannot expect to return your investments in 3 or 5 years, and it is whatever positive things we say about all these new changes, but still nobody can guarantee that the same tariff will be used at the time when the decision to invest is taken, and later when the project will be implemented. So that is why it is so difficult to invest in all these areas, in energy supply area, water supply. Tariff regulation is preceded by investment programs. So some investor prepares an investment program, a plan, and this program is approved in the Ministry of Energy, for example, and they see all measures are included into this plan, and those sources of financing which support this program, and it should be taken into account when tariffs are set up. Yes, I know there are difficulties with profitability of this project, but we have certain limitations. We cannot simply increase tariffs to the maximum. So here, very often, this is not a problem of tariffs or some non-transparency in this area, but also it is how disciplined people are in paying their bills, customers paying their bills, because it is only 90% of all payments that are paid on time. Okay, thank you. Microphone, please. 2 years ago, we had a request from a group of banks and the group was headed by Mr. Chistiakov, and they asked us to look for a mechanism to invest in infrastructure projects. And we have had so many meetings and discussions, and together with Mr. Novikov, our director, and Mrs. Nabiulina. So, as a result of all this, Article 38 is included into the law on power supply, and I believe it is better than concession investments. The major problem, it seems, is not to provide an appropriate legal instrument, but to offer to municipalities clear programs, investment and production programs. And we said, okay, give us a specific regulatory agreement with specific properties and specific equipment that you are ready to install, and please write out our obligations. And I'm sure that we will find common points on each of those items. So, but unfortunately, we haven't received any detailed agreements. So are you saying that it is manual regulation? I don't know. If we speak about long-term tariffs, you know, Ivan gave you an answer. Yeah, we are trying to move towards this long-term tariff policies, but there are also obligations on the part of the investor, the investments and equipment they are going to upgrade and so on. And political risks, you know, we cannot guarantee that there will be absolutely no changes in tariffs for a long time. Yeah, we need to speak about tariffs, but they can be qualified using a certain investment parameters. So these adjustments can help us, but only when we have absolutely clear, well-written obligations on both parties. Only then we can identify our approach. Thank you. So you are representing the Federal Tariff Service. Yeah, so you are saying that, yes, we need to see obligations of both parties, and there should be specific items included into agreements. And now I would like to give the floor to Priscilla Yurki, partner of Rochier. We know you as a company servicing Scandinavian countries, and you know that you have some road projects in Finland. Could you please tell us, how do you manage to build roads using PPP projects? And as far as I know, in Finland there are no toll roads at all. But you manage to structure these projects, and you ensure certain profitability levels for investors.
Also on my behalf, I'm very pleased to be here and try to explain from a practical point of view the projects we have had in Finland, and just first few reflections on the discussion we have had here. There is no PPP law as such in Finland, and there has never been any discussion about introducing specific PPP law. We have, in the introduction of these PPP road projects, changed our tax laws in the 90s to accommodate the long-term depreciation of the investment by the project company, and then we think that the public procurement laws care for the competition law related aspects of these projects. So no discussion on that. Then another topic which I which was mentioned in the beginning was whether the PPP is a model which is used in the scarcity of financing for these projects, and I just want to note that even in Norway there are PPP projects, although the oil money is piling up, because they see that it's an effective way of procuring roads, giving the benefits of construction, and not entirely looking at the interest rate discussion, which has been a topic in, for example, in Finland, where the principal objection by the Ministry of Finance has been that the public sector can borrow money at a lower interest rate than the private sector, so why to have PPP projects? But if we go through my presentation, to enhance discussion, I have been involved in PPP projects representing all other parties but the public sector, so I will raise some comments on these angles, and please challenge the views and compare my comments with your own experiences so that we can have a good discussion. Then there are some notes to the community, PPP community, how it should enhance the feasibility of the projects and keep on talking about these projects. Admittedly, there have been much more talk and conferences on these things than actual projects, and there's a lot of variation of what is actually a PPP project. We have seen a lot of lease agreements labeled as PPP projects, but to me a genuine PPP project is a project where there's a public sector procuring service from the private sponsors, banks lending money, and a lengthy discussion about allocation of risks and somewhat long project financing period. Then I have some comments on notes on where the PPP model from our angle would best fit to. But just to illustrate where we are in terms of the Finnish market, we have had, my criteria for genuine PPP projects, we have by all standards less than 10 projects. They usually tend to be valued at around 500 million euros, and they have been on the market so rarely that there is really a challenge for the knowledge transfer among the various parties. This includes not only the authority, there are changes over the years in persons, but this also applies to various advisors, technical, accounting, and legal advisors. I've listed here the project from the 90s, the one we had in 2005, and then there have been a couple more recent projects, even a rail project. There was a significant rail project which was suddenly aborted by a decision by the government, and that was certainly not good marketing for the PPP projects, because a lot of parties had spent a lot of money on planning and bidding. If we think from the authority point of view, we have seen a clear development. The first one was clearly a project where the authorities had decided that let's try this for once. This was 1997. We more or less adopted UK style documentation, and it was translated into Finnish for the final execution, but but by all standards it's a direct copy from a UK model, not much tailored for the local circumstances. Nevertheless, it was quite well received by the constructors and sponsors because it looked as a very profitable project. And so was it. It was now handed over to the road was handed over to the government in last year, and the profits which the sponsors were making were really significant. Then in 2005, the government spent a lot of efforts in developing a more genuine Nordic model for this kind of projects. Also, European Investment Bank came into the picture at fairly early stage, and that affected the process. One can never know what would have happened if the constructors would have said that, well, we don't need EIB, or whether ultimately the government would have said that, well, we don't do this project if EIB is not involved. You never know about the real facts, but there was a sincere attempt to also consider having fully financing without this without EIB and Nordic Investment Bank. Then in the last completed, and that means signed and financially closed project, we had again some new aspects. We had through competition by a couple of foreign companies who were doing extensive due diligence, and it was in a way sometimes quite amusing to sort of see what kind of due diligence will be expected from a country like Finland, being a member of the European community. But of course, if you go by the book and want to tick all the boxes in your project management handbook, then that's fine, but that's quite expensive and time-consuming. The general features of these road projects have nevertheless been that the last two ones, that they have been completed, the negotiations have been completed in a very short period of time, like 4 to 5 months from the announcement of the winner to the financial close, and that is thanks to our authorities, which are quite flexible, negotiating, using English language and accepting to primarily negotiate in English, and then even accepting that all the banking documentation is only made in English, whereas the service agreement ultimately will be signed in Finnish. If we then look at how the constructors have perceived the negotiations, in 2005, in fact, one of the consortiums bidding for the project came with a quite novel idea of building the road in a manner which enabled them to offer a construction time which was 3 years, whereas the other bidders were offering for a construction time of 4 years. And of course that means that the service payments are triggered in one bid 1 year earlier than in others, and that affects a lot the financing, and it's hard to beat that kind of an offer, and that back in 2005 meant that there was actually no best and final offer phase, but direct negotiations with one of the bidders. In 2011 project, because of this very thorough due diligence and approach, and I would say the presence of the very welcome presence of foreign corporations, foreign construction companies bidding for the process, there was extremely careful public process from public procurement law point of view, and this meant that the authorities were punctually revising the documentation. We calculated some 15 revisions, and that of course is good for the law business, but not so nice for the overall project management, and the bidding costs were significant, but ultimately we still we were able to have the signing and financial close. I think it was 5 months from the announcement of the winner. Then, if we take the lender's perception and view, it's hard to remember what the financial market was back in 2005. The only financial problem at that time seemed to be that the interest rates were going up, and that meant that in the financial modeling, the only problem was that the budget limits of the authority were at the edge, and there was the risk that the authorities would have had to cancel the whole project because of not sufficient budget limits. Here we had very stable, financially stable bidders, and it seemed to be that generally at that time banks were very confident with looking at the partner risk, i.e. the companies they were working, rather than having a very thorough due diligence on the project documentation as such. It was I don't think that there is anything easy or loose in the documentation, but still the banks were different at that time. In 2011 project, there were a lot of different financing alternatives discussed. We discussed the involvement of pension funds. In Finland, they are pension insurance companies, which by their nature, they should have long-term investments in Finland, not only in Finland, but this kind of project should fit extremely well into their portfolio, and they participate with some smaller stakes. I note that also the insurance issues suddenly started to delay the project in the final phase. So it is so that this project tend to have different delaying aspects. I would say that if in 2005 the main obstacle for the project were some flying squirrels which were found at the road area, and that led to a lot of environmental issues. Then in 2011 we had a big fight again with insurance brokers who didn't really want to understand the solid ground of stone in Finland, and were trying to find all kind of archaeological problems in areas where all people with common sense would know that there has been no villages 500 years ago as probably in Central Europe. To enhance the discussion, there's a small community of lawyers and financial advisors involved in this project in Finland, and we are glad to see that there is some new project announced by the government for 2014, and we very strongly try to. It's probably comparable what could be arranged through legislation in other countries, but we try to endorse the importance of following the working patterns which have been developed through the projects. Also, it's important to see that the consortiums and the sponsors should seek for their own financing and limit the government interference with the bidding phase. That would ensure that there's all kind of technical innovation is used and introduced by the parties, and the government will not dictate the kind of project or the kind of road they want to have. If I then try to see what is the limitations for PPP projects in a small market like Finland, Finland is a country which is investing currently into nuclear power plant. We have 4 operating nuclear power plants. 1 is under construction and 2 is under bidding process, and if we have this kind of, let's say, 6 billion euro projects going on, it will absorb a lot of resources from technical advisory field as well as lawyers and financial. We don't have resources for many PPP projects at the same time. We have seen foreign advisors coming to the Finnish market, and this includes not only this includes lawyers and financial advisors, and that's very welcome. Then another aspect which I referred to already is that these projects should not be too rigidly guided by the authorities. There's a tradition by the authorities that they have had in-house resources doing the design, and then you simply exclude a lot of innovation from the project if you, for example, in a hospital project, try to plan everything ready and then just have a bidding process who has the cheapest financing and the cheapest construction costs. The innovation should have more room in this kind of projects. Then I'm of the view that electricity project, power plant project do not really very well fit to PPP market. It should preferably be roads, basic infrastructure where the government takes a long-term, makes a long-term arrangement, minimum 15 years. In a railroad project, probably up to 30 years, and then there will be a combination. Then there can be a combination of constructors, financial sponsors, and an aftermarket for these project company shares, and we have. Also seen that for example, in the project from 2005, now that it has been completed some 4 or 5 years ago already, the project company shares have been transferred further by the initial sponsors when there is we can the parties can really make a mathematical exercise of the right pricing, and thereby also the construction companies will have more capacity for new projects in their balance sheet. This brings us to my last slide. I think that for effective market, processes need to be standardized so that the bidding costs will be reasonable. That will mean that there will be a lot of interest on the market, not only by domestic players who in a way know that they will get the job anyway, whether it's PPP or not. There's a couple of, let's say, there's 10 relevant companies someone will construct the road anyway if there's a decision that this road will be built. Ultimately, it's a question of the financial market looking at where to invest and where to have the projects, and I've said that we would need a crystal ball to see whether the financial market are interested on these projects. This changes from time to time, and I think that little bit some kind of a bond financing and this kind of introducing these kind of elements would make this project even more interesting, and then the relative strength of the Nordic countries should mean that these are very, or should I say, quite safe places to have projects like this. Thank you very much. I'm very happy to answer any questions you may have.
Thank you very much. Думаю, что господин Прусила, если у кого
If there were any questions pertaining to PPPs in Finland after your detailed presentation, there are no such questions. I have a question to Marco Graziani. Could you please tell us, is in Italy, are you concerned about PPPs in Italy? Are there debates where PPP is needed or not? Are there PPP projects that are revisited? So what do you think in Italy about investing in infrastructure through PPP arrangements?
Thank you, and thank you to both the moderators for inviting me to provide you some general comments about Italy and our situation. Italy is, if you want, some in the middle, in the sense that it is a country where there is already an industry, although it is not so developed as it should be, because many infrastructures have been built. PPP is being used. I will give you some really a general overview of where we stand at the moment. And at the same time, we are a civil law country, and our legislation is in the process of being improved, especially in the last years. So probably it would be good for me to give you some of the reasons for which our legislation needed to be improved, and then we will see that some of the issues are really common to those that are being addressed today. Let's quickly start, where we started. In Italy, PPP started in the early 90s, and I wanted to start with this because actually this is the first relevant case in Italy, but it's something that I, in my personal life, still experience every week. I mean, I live in Rome, but I have an office also in Milan, and each week I go to Milan, I take a fast train, and I take advantage of this very good infrastructure that was built, which is the high-speed railroad. This was built actually when we had no special pieces of legislation about PPP, at the time it was take advantage of some special laws about the railway, the improvement of the railway network. Then in the middle 90s, some rules were introduced. Although in Italy, we don't have a single set of legislation for PPP, we could say in general terms that contractual PPP is regulated by the Public Procurement Code. But we have other rules for institutional PPP, what is called institutional, so where there are special companies that are jointly participated by the public and by private partners. And these rules are in other sets of legislation, especially in the code for local public authorities. I would not get into the details of what is the definition in our legislation. This is just for you to let you know that effectively also in Italy, I mean, the basics, especially for important infrastructure programs, the basic structure is the public work concessions. We have various types of actually, we have various types of different arrangements that are possible in this context. And the legislation is continually improving in this sense. We had a new contract, for example, that was introduced last year, which is called the availability contract. I mean, in this sense, there is attention to market demand and need to adapt the legislation to the specific needs of the market. Obviously, the most used arrangement is the works concession on a project financing basis, obviously, and especially for largest infrastructures. I mean, the project financing structures are the more used. When we talk about works concessions, obviously, we talk in Italy also about competitive tender procedures. And this entails, as I will tell you in a couple of minutes, I mean, this entails you some issues, effectively, also from a legal perspective, some complexity that is probably one of the more critical issues, especially in a civil law country as Italy and with a certain tradition in the public administration. There are various types of competitive procedures. I won't address them all at all. What I would focusing on is probably something that has not been discussed before, which is a factor that strongly influences in Italy the market, which is the accounting of PPP by public authorities. This is one of the key issues when a transaction is structured, actually, because the accounting treatment has to comply with European standards and with European principles of accounting. And basically, if there is an improper allocation of risks, the transaction cannot simply be implemented. In addition to the allocation of risks, another critical issue is the amount of public contribution or the amount of public support to a certain transaction that could formally meet the requirements for off-balance sheet treatment on the side of the public authority. And this is also an important issue because in many projects, especially in those that are called the cold projects, so where there is a significant need for public contribution because there are specific risks that need the support of the public. For example, you have a need for a public contribution, and this is the limits set by the accounting standards are very important in this context. The allocation of risk, obviously, we will also touch upon this later. Allocation of risk is always a very difficult task, and in addition to the usual risks that are taken into account when structuring this transaction, you may have all sorts of risks for which you should basically allow some and factoring contingencies in the project. This is an issue often, especially where you have administrative procedures at the beginning that are very strict in the way that public authorities need to approve a project and provide and give the concession. Just a very simple example that was mentioned recently. I mean, I was discussing with a colleague who is a former senior judge of our administrative courts, and we were discussing the project that is being conducted now in Rome for the constructions of the new line of the underground in Rome. So where is a private party that could take the archaeological risk to build an underground in Rome? Nobody. So probably only the public authorities should take this sort of risk and should allow some contingency in the structuring of the program. And this is a problem when you have strict administrative procedures that not always allow the public authorities to be so flexible. This is. So, I mean, very quickly moving about what are the critical factors, what have been the critical factors in Italy. As I said, we have experienced in the last 10 years a significant growth of PPP, many projects, but probably the development is not comparable to that of other jurisdictions. I mean, leaving obviously aside the UK, which is obviously different to be compared, but also if we think about Spain for a certain period, has been growing much faster than Italy. So I've tried to identify at least three main factors that have played a significant role. One is the lack of sufficient competition among private participants. In Italy, there are few, I mean, there is a market, but there are few participants, and most of them are constructing companies. But this is due, as we will see, also to legal and administrative constraints again. Another one, which is very important, is the higher cost of funding. I mean, funding in Italy, according to a research a few years ago, it was 2010, so after, I mean, obviously just in the middle of the financial crisis, but the average financing, the cost of finance was above, I think, 9% or 10% above the level of funding in the UK. So, I mean, this is a real difficulty. And this is due because funds are mainly channeled through the banking system, and there is no or very, very little recourse to capital markets. We have touched upon this before, and I will come to this at the very end of my presentation. And the last one is the difficulties in allocating risks. I mean, what I discussed just a minute ago. But on the side of the public authority, there is also, I mean, something for which, I mean, they might be blamed, probably, if I can use this word. I mean, the use of PPP has not been as effective as it should have been. I mean, the first reason is that the legislation is focused on the tender procedure mainly. So on strict procedure that are mainly ruling the initial phase, the granting of the concession. And so, I mean, while obviously for such a long-term contracts, you should allow flexibility to look at the whole duration. And on the other hand, although it is obviously a best practice that to have a value for money estimation, which from the perspective of the public authority is the real, an actual tool for analyzing whether it can have a benefit from a project or not. The focus of the law is mainly on the economic and financial plan for judging the feasibility, but this plan is usually drafted by the private party. So, I mean, things are changed. I mean, I'm just identified what have been in the past, the critical factors. And the last one is the motivation that in many cases, bearing in mind what I said about accounting restrictions, the motivation sometimes, especially I would say for smaller projects, obviously not for large infrastructures, but if you think about municipalities or regional governments, sometimes the motivation of a transaction has been more to have, to keep off balance sheet some construction costs that could have been relevant, rather than to really look at the benefits of a project from a value for money perspective. And the legal and administrative issues are common, I mean, in many situations as a critical factor. I mean, the first problem is linked to the duration and the complexity of the approval procedure, as I was saying. There are various public parties involved in many cases. It's difficult to coordinate them. Rules provide for long procedures. There was more in the past a lack of specific competence within the public authorities. And what is very important for the private party, there was a high degree of uncertainty in the awarding procedures. A lot of litigation was possible, and this obviously does not give the sufficient certainty to the private parties, and was discouraging also, I mean, someone to compete in certain bids. That's why, I mean, we come to my conclusions in the last few slides that describe to you in very general terms what, especially in the last couple of years, the Italian authorities have tried to do in order to improve the legislation. Obviously, legislation always needs to be improved. I mean, it's always a process in trying to taking into account also the past experiences. The amendments have interested various parts of the legislation, starting from the planning phase and going to the last of the risk that I mentioned, so the litigation risk. Very quickly, I mean, as far as the approval and awarding procedures are concerned, the new rules now provide a sort of standardization of the feasibility studies that need to be provided. There are some centralized bodies that should control whether these studies are prepared by the competent authorities. And what is very important, what has been introduced is the need to look at the bankability and the financing issue. So, I mean, from the very starting of the project. So when the public authorities will start assessing the visibility, they now need to look also at these financing issues. And the awarding procedure now, I mean, is also possible not just on the basis of a preliminary study, but in some specific situation, what is needed is to get to a more advanced stage, if you want, for some specific project. What is also possible is to get to the award when there is a more complex and a more detailed drawing of the project. I mentioned before the issue of contingencies and of projects where you cannot simply rely on external finance because you need also a public contribution. And taking into account the restrictions also given by the accounting rules that I mentioned, I mean, what has been realized by the government and by the parliament is that something should be done. And now, I mean, what is possible is to have a number also of alternative measures for compensating the private party. So if the public authority cannot provide direct funding because it would breach the accounting limits, now there could be alternative measures. I mean, I've mentioned just a couple of them, but one of these are on the tax side. There are a number of tax benefits that can be given to the project company directly or to the private partner in terms, for example, of setting off its tax debts with the contribution that it should give. I mean, there are a number of complex procedures in these, but tax benefits are a way of indirectly contributing to the project. And in some cases, I mean, what has been done is also, since most of the private parties, many of them are constructors, building companies, I mean, is to provide them with additional building rights that they can use. And this is a way of an indirect compensation, as you may understand, for the effort that they're putting in financing the transaction. And the last type of measures in this respect are those that are aimed at discouraging the litigation and in reducing the what I've called here the annulment risk, so the risk that a judge can say the whole procedure is void and we go back to square one. And this has been done through various measures, but one of them, for example, has been to restrict very much, compared to other procedures, the terms for challenging the acts that pertain to the awarding procedures, and to have a more strict review and possible also penalties in case of rash litigation, just for the sake of stopping the public authority to award the concession to a competitor. And for strategic infrastructures also, now the risk that the whole procedure can be declared null and void is really much lower because there are new rules for this. And I mentioned before, and this will be my last slide, the other constraint that we have experienced, that is the limited access to capital markets. That's why last year Italy introduced specific rules aimed at having the possibility for the players involved to issue what we have called in our legislation the project bonds, these infrastructure bonds that someone discussed before. The legislation is quite recent. We're at the moment looking at the first opportunities to structure these. They are interesting measures. They will probably need to be amended, but in a nutshell, obviously, they provide a number of derogation to the ordinary limits that exist for issuing bonds for private companies, and a number of tax advantages also, both for the issuer and for the investor, including institutional foreign investors that will effectively be allowed to subscribe for these bonds on a tax-free basis. All investors that will be based in a country having a tax treaty with Italy, and most of the countries have tax treaties with Italy, will be allowed to receive proceeds free of Italian taxes, as if they had invested in an Italian government bond. So, I mean, this is an interesting. Project bonds can also be issued to refinance existing debt. So if you want, it's a way of trying to sustain the market to some extent. I've tried to summarize as much as possible, I mean, the key remarks from our side, but I'll leave you, I mean, for any additional question. Thank you.
Спасибо большое.
Thank you very much, Marco. From your presentation, I've seen that we have a lot in common with Italy. Inflexible bidding procedures, expensive financing, lack of access to capital markets, lack of expertise, not only on the side of the public authorities, but on the private side as well. Parties cannot come to an agreement on how to share risks, how to divide risk between themselves. Unfortunately, we are running out of time. Let us start the Q&A session right away. Alexei Zverev wanted to ask a question, right? Let's start with you. It's going to be a very short...
You may say that Italy is somewhere in the middle of countries on the PPP development, and you may say so, which is probably right, but there is one particular area where Italy is a pioneer, and that's unsolicited proposals, with the so-called Merloni law being possibly the most quoted piece of legislation in terms of its comprehensiveness in regulating, in providing it with a set of rules regulating unsolicited proposals. My question is, has there been any implementation of this law in practice since 1994, if I remember correctly, the day of the law? And what are the main lessons learned? Thank you.
Well, let's say yes, the date was correct. The Merloni law dates back to 94. Actually, on unsolicited proposal, I mean, there have been obviously amendments later. The experience is that, I mean, there are cases in which this has been used. I mean, this situation don't relate to large projects at the moment. So it's more about projects at, if you want, more at local level. But effectively, I mean, this is something which is rather innovative, especially for a civil law country, effectively. And it is something that I mean, probably the problem that we're experiencing is linked to the fact, as I said before, that we have lack of competition, really. I mean, so, I mean, having few private parties in the market limit the possibility that this tool can give to those that would like to use them. So there are situations in which it's being used, but more at, if you want, a local level rather than for larger projects.
The reason why I'm asking that is because it's not regulated at all in Russia, and very recently there have been some moves to start thinking about it, and that's why I'm asking you if there has been any experience in applying the law in practice. But
yes.
Thank you.
Yes, yes. I see, I mean, that there have been, as I said, experiences, and so it's something that we could probably build on. I mean, the reluctancy in general of the market in the past was linked to the two factors, also the possible litigation around this. I mean, since the recent amendments came in between 2011 and 2012, we should hopefully see if the recent amendments are a further enhancement, will lead to a further enhancement also of this very interesting tool.
Спасибо. Да, пожалуйста.
Thank you very much. Wait for the microphone and ask your question.
Simmons. As someone who's focused on energy and infrastructure now since the late 90s and who remembers the Norman Lamont statement of 92, I've looked at and worked in most European PPP markets. And I think listening to all the presentations, The one thing to bear in mind is if there is the political will to make a market work, it'll happen. So we had a lot of discussion about whether a PPP law is required or not, how to amend laws. The only reason why the UK PPP market flourished was because you had an ideological creation of the markets which wasn't very well executed by the Conservative government, followed by a massive quantum jump in Britain's investment in social infrastructure. For 30 years prior to the Labour government, no new hospital had been procured, and they procured 70 in the space of 5-6 years. It was a massive investment. They moved obstacles aside. The off-balance sheet, on-balance sheet question is often quoted. It's a big issue in Italy. Other countries, it's a big issue. In the UK, most projects were never off-balance sheet anyway. It was often a criticism. The UK fell out of love with PFI, has fallen out of it. The coalition government at the moment doesn't know what to do. It's invented PF2, which isn't really very successful yet. It's run out of money for social infrastructure. It's mainly thinking about economic infrastructure. So looking across the rest of the continent, where are the success stories? The hottest market in Europe at the moment is the Netherlands. The Netherlands, in a very no-nonsense way, I worked there for 5 years in the 2000s when PPPs were being looked at. They did one project a year. It was slow. It was a bit like Finland. Finland never gets momentum going. Now, everybody wants to be there. Why? The government's committed. It has a program. It has come up with standard approaches which are reasonable and bankable. They haven't tried to push the envelope on project risk to one way or the other way. They haven't tried to squeeze it into silly directions. They deliver on time. They have the most transparent bidding procedure. You know at every stage where you are. They score you on your design, they score you on your technical ability, and they score your financial. And you know where you are. So if you get into the last round, you know you're bottom of the three, and you know you've got to pull your socks up. And they stick to the timetables. And you talked about closing in 5-6 months. Well, 3 months is usually from PB to financial close. That's how you make it work. Next door, the Belgians are doing quite a lot as well, but they can't resist fiddling. They put really strange structures in, and it all takes time. So if you want infrastructure, if you want to one other thing you need to do is you need to be open rules that allow not just domestic vested interests to corner the market. If the international markets get the feeling that the only way you can make progress is by having the inside track, then there will be a price to that, and that will also slow you down in terms of your development of your market. So, I could go through every jurisdiction on the continent, and we can talk about, and we've heard a wonderful presentation on, two wonderful presentations on 2 European markets, and obviously discussed the Russian one. But that would be my advice. If the government really wants it, then the laws will change in the right way, and you will get the international investment. Last point, capital markets. Everybody wants the capital markets to fund because the banking system is really struggling to deliver. Having said that, the end of February in the Netherlands, they did a 28-year road financing, 800 million euro, no problem. They found the investors. So everybody else is saying there's no bank funding out there for 28 years. The Dutch did it no problem because of this program that they're doing. But we need bond financings. There are all sorts of ways of doing it. The model is there. You need to find other ways of monitoring risk. But if you want the capital markets to develop as well, all of these things that I mentioned will allow you to fund on that basis. Thank you.
Спасибо большое. Действительно такие очевидные.
Thank you very much. Very obvious recipes you've shared with us. And it is strange that these obvious recipes have not been in use to the full extent. Openness, project pipeline, clear understanding of the tender procedure. Well, we should not convince anyone that all of this is necessary. It is clear for everyone, but still, for some reason, it doesn't always work. We know examples from Russia's cities and regions. Dear colleagues, we have run out of time, but I must allow some more questions, a traditional question for Albert that he wanted to ask of himself about ranking. Whether we need the PPP law here or not. There was, the PPP law, if we had an option to replace the concession law with the PPP law, I would tell you that it would be better to amend the concession law, but since there is no such option, well, I didn't say this. Okay, if we don't have any further comments or questions, I would like to thank everyone for participating in this discussion. I hope it was useful for the participants and speakers. For me, it was very useful, and I hope to see you in 1 year's time here at this forum again.